So here we are going to discuss regarding this Election Commission of India. That is Election Commission of India article in the Constitution is from 324 to 329. First important thing is there is one this chief election commissioner, another is two election commissioner and election commissioner. So it is a multi-member body. So election commission of India is a multi-member body. But one thing we need to note that before 1929 this body was not a multi-member body, but it was a single body. But since one thing also we need to know, in 61st constitutional amendment 1988 the age limit of this voter was reduced from 21 years to 18 years. Because of that workload was increased, and so this body became multi-member body. One more thing we need to know, this election commission of India actually came into effect 25 January 1950, and this 25th January is considered as National Voters Day. Now next thing we need to know, who appoint this chief election commissioner and other election commissioners. It is the President of India who appoint this chief election commissioner and other election commissioners. One more thing, how many election commissioners should be there, how many regional commissioners should be there, who will decide this? So it will be decided by President of India only. So President of India fix the number of election commissioners should be there. So already President of India has fixed two election commissioners right now. So we are having one chief election commissioner and other is two election commissioner. Next thing we need to know, who fixed the tenure of election commissioner and chief election commissioner. So tenure of chief election commissioner and other election commissioner is fixed by Parliament, and Parliament fixed the condition of the services plus tenure both. And for that Parliament has enacted a act. In that act Parliament has given conditions of service and tenure. So here tenure is given 6 years or 65 years of age, whatever the early. So if 6 years actually became early before the turning of 65 years of age for that person, then person will retire. Or suppose example, person's age is 63 years, so only after 2 years a person will retire instead of completing the tenure 6 years. So whatever comes early, 6 years or 65 years, that is the tenure. Other conditions of the services, रिलेटेड अदर कंडीशन ऑफ सर्विसेज के लिए पार्लियामेंट हैज रिटन दैट कि सेम स्टेटस एंड पे एंड पर्क्स एज जजेस ऑफ सुप्रीम कोर्ट. दिस थिंग वी नीड टू नो. सो चीफ इलेक्शन कमिश्नर एंड अदर इलेक्शन कमिश्नर्स एंजॉय द सेम कंडीशन ऑफ सर्विस दैट इज एंजॉय बाय जज ऑफ सुप्रीम कोर्ट. सो दिस थिंग वेरी इंपॉर्टेंट फॉर प्रीलिम्स पर्पस, दिस इंफॉर्मेशन कि जज ऑफ सुप्रीम कोर्ट. Okay, they can give 4 options ki what condition services of election commissioner or chief election commissioner are same as option में आपको मिल जाएगा. फॉर सुप्रीम कोर्ट जज, सेकंड हाई कोर्ट जज, और थर्ड इज CAG, एंड अनदर फोर्थ इज UPSC चेयरमैन. सो राइट आंसर विल बी जज ऑफ द सुप्रीम कोर्ट. Next thing is removal. So who will going to remove, how the removal is possible regarding chief election commissioner and other election commissioner. So chief election commissioner is always removed in the same manner as judge of the Supreme Court. Again ध्यान रखना, it is a judge of the Supreme Court. Even though judge of the Supreme Court and judge of the High Court both are removed in the same manner, but still answer should be judge of the Supreme Court only. So in the manner, so chief election commissioner is removed in the same manner as judge of the Supreme Court. So how this judge of Supreme Court is removed? Judge of the Supreme Court is removed on the 2 grounds, and these 2 grounds are, first ground is proved misbehavior and second is incapacity. These 2 grounds are given in the Constitution of India itself. So on these 2 grounds only chief election commissioner will be removed. Another important thing is this Supreme Court judge is removed by passing the resolution from both the houses by special majority. The same way chief election commissioner also will be removed by passing a resolution for the removal from both the houses through special majority only. That things we need to know. So here the thing is that for example, if it is starting from the Lok Sabha, if removal process start from the Lok Sabha, whenever it comes from the Lok Sabha, then first important thing we need to know कि 100 members support is required. If it is started from the Rajya Sabha, then 50 members support is required. After passing this, okay, after passing of this Lok Sabha, so before that then investigative committee will be formed. Investigating committee will consist of Chief Justice of India or judge of the Supreme Court, or second member will be Chief Justice of the High Court, third person will be the eminent person. This 3-member committee will going to investigate the matter, and then this will put for the vote in the Lok Sabha. If this is passed with special majority, then it will reach to the Rajya Sabha. Then Rajya Sabha also, if passed by special majority, is then only this chief election commissioner will be removed in the same manner as judge of the Supreme Court. Next thing is ki other election commissioner, how they will be removed. So other election commissioner will be removed by the president on the recommendation of chief election commissioner only. So the thing is that for removing of election commissioner, we do not require the same process as the process given in the removal of judge of the Supreme Court. Here only thing president need to do ki on the recommendation of chief election commissioner only president can remove, president cannot remove on his own. But that means the thing is this ki chief election commissioner and election commissioner, they do not work during the pleasure of the president, unlike governor of the state. Correct. So the thing is this why this thing has been given. So this thing is given just to protect election commissioner. So chief election commissioner role here is to protect or shield the election commissioner. One more thing we need to know, कि this is a multi-member body. It is one chief election commissioner, other is two election commissioner. If any decision need to be taken, decision must be taken by through majority only. Correct. So the thing is that another important thing, whenever there is a difference of opinion happens, decision should be by majority, and whosoever giving a dissent note, that note must be recorded. This thing actually decided in Tamil TN session case 1994, and here Supreme Court has ruled this thing. Chief election commissioner and election commissioner all are equal, they are not, that means election commissioner, this election commissioner, they are not subordinate to chief election commissioner, all are equal, pay and perks are equal, conditions of service are equal. So that the thing is that decision also should be made by majority only. So here chief election commissioner cannot override over these two election commissioners. Next thing is whatever the flaw is there in our election commission of India. So first flaw is no qualification is given. First flaw is there is no qualification is given in the election commission of India. For example, no legal qualification, no educational qualification, no such qualification is mentioned under Constitution of India. Even not minimum age, not no experience, nothing. So that means executive can appoint any person as a chief election commissioner or election commissioner. Second important flaw is no debar. That means these election commissioners or chief election commissioner, they are not debarred from taking other government of India employment after retirement. That means after retirement there is no debar. So because of that, sometimes politicizations happened. After the retirement, election commissioner or chief election commissioner used to join the political party. Next, third important flaw is this: administrative expenses of election commission, or the salaries and the allowances and the pensions of this chief election commission or election commissioners, they are not charged on the consolidated fund of India. See, there are two types of expenditure is there. One type is known as charged. Okay, two types of expenditure is there. One type expenditure is known as charged on, another expenditure is charge made from. Correct. So this is charged made from, because charged made from they are votable, and charged on they are not votable. So the administrative expense of election commission, salaries and allowances, they become the votable part of the budget, not non-votable part of the budget. This is again a disadvantage to the election commission's autonomy or independence. Now we will discuss what is the powers election commission is having. So we can divide powers into three parts: administrative powers, advisory powers, and quasi-judicial powers. Now first thing is, what are administrative powers are there? So administrative powers are actually, first important, election commission define the electoral boundaries. So whenever election commission define the electoral boundaries, it is defined actually on the recommendation of delimitation commission of India. Second important administrative power is register or deregister political parties. So register and deregister political parties. Third important power, that is this model code of conduct. So enforcement of model code of conduct. Model code of conduct actually it is enforced when the declaration of election date announced. For example, recently for the state Maharashtra as well as Haryana, election date has been announced. So in these two states, model code of conduct already became enforced. Fourth important administrative power is this: to track election expenses. Correct. Next is another important power is to appoint election observers. Another important administrative power is to appoint election observers as well as expenditure observers in elections. Okay, this is another important administrative power election commission is having. Next is advisory power. कौन से advisory powers are actually first important is election commission used to actually advise president of India regarding disqualification of member of parliament. Whenever there is a question on the disqualification of member of parliament, for example, suppose member of parliament is not a citizen of India, or suppose the age is less than 25 or 30 in case of Lok Sabha and Rajya Sabha. So in such situations or any other disqualification cases, president takes decision, but president always takes decisions after taking recommendations from the election commission of India, and whatever the decision taken by election commission of India, okay, whatever the decision that is taken by election commission of India, the decision will be binding in nature over the president. Same way at the level of state, in case of disqualification of MLAs, president always advise the governor, and governor take decisions on the advice of the election commission of India. And another important thing is election commission of India also advise high court and supreme court whenever the matter regarding election dispute arise in these courts. Okay, whenever matter regarding election dispute arise on these supreme court and high court, in that case also election commission of India advise these two courts. Now comes to quasi judicial bodies. So quasi judicial bodies actually are, for example, first is election commission of India is empowered to settle the dispute whenever there is a dispute, for example, the regarding election symbols, regarding political parties deregistrant, whatever the election dispute happened, the election commission is empowered to take decisions. Second important power is power to act as a court. Power to act as a court when there is a dispute regarding election symbol, political party's name, color code, all these things ke cases may be election commission is having quasi judicial power. Another important thing we need to know ki what are the elections that election commission of India conducts, whatever the elections conducted by election commission of India. So election commission of India basically conduct elections of the MPs, that means Rajya Sabha and Lok Sabha, Rajya Sabha both MPs. MLA's election, that is MLA, that is state legislative assembly election and state legislative council election. So council election may be called MLC. So that elections also conducted by election commission of India, and election commission of India also conduct the election of president of India and vice president of India. Next thing we need to know कि local panchayat and municipalities elections, that is 73rd and 74th amendment, local panchayat and municipalities elections, they are not conducted by the election commission of India, but they are conducted by actually state election commission. One thing we need to know is they are conducted by state election commission, and state election commission also a constitutional body, that we need to know. For example, election commission of India is also a constitutional body. Same way state election commission also a constitutional body under article 243 of Indian constitution. So this local panchayat and municipalities election is conducted, okay, under the supervision of state election commission of India. But one thing need to know कि election commission of India is always advised by state election commission is always advised by election commission of India. Now some article we can remember. One important article is article number 326. This article number 326 says that इसको बोलते हैं adult suffrage. That means who will be the voter, it will be decided based on adult suffrage. That means there shall not be a discrimination based on race, caste, sex, place of birth and all these things regarding voter. So only discrimination is based on years. If anyone is more than 18 or equal to 18 years, that person is eligible of this right to vote. So one thing we came to know here is right to vote is a constitutional right, not a fundamental right. Simply why it is not a fundamental right? Because 326 does not actually come under part 3rd of the constitution of fundamental right, but it is outside of part 3rd, because part 3rd mein article number only 12 to 35 is there, but this is article number 326. Actually it is a constitutional right, not a fundamental right. Another important article number 324. This article 324 actually talks about the powers and functions. This article 324 talks about powers and functions of the election commission of India, superintendence of the elections. Next article number is 329. So most of the powers are coming to the election commission of India through article number 324. So many times it is very rare that election commission of India used to invoke this article number 324, but they can invoke article number 324 if in election any electoral malpractices are done, then with the help of article number 324, election commission of India used to declare that election as invalid. Next is article number 329. Actually, article number 329, it bars the interference by the court in electoral matters. That means in the electoral matters, court, that is High Court and Supreme Court, they cannot interfere. But if any dispute happen regarding election, then election petition need to be filed before the court. Okay, that's another important. What are the important innovation that is brought by Election Commission of India? So one innovation is Model Code of Conduct. This Model Code of Conduct, first actually it was applied in 5th general election. What is general election? General election is nothing but Lok Sabha election. Okay, so first time Model Code of Conduct, it was it applied in 5th general election in 1971. One more thing, this Model Code of Conduct does not having any statutory backing. That means there is no legal act enacted by the parliament that is supported this Model Code of Conduct. They are simply guidelines, that is do and do nots. Another important reform taken by Election Commission of India is this disclosure of antecedents by the candidates. That means candidate need to disclose their criminal background or criminal history. That was actually done in 2002 when Election Commission has actually given this condition after taking directions from the Supreme Court, and then this Election Commission of India, by the using of power article 324, and made this mandatory for every candidate to disclose the criminal history. So this is the thing that is need to be completed for this Election Commission of India, for at least prelims purpose. For mains purpose, the most important topic that we need to know, that is election reform, and whatever the various commission and committees are there, that also we need to take care of this. Thank you.